Hello viewers, I am Dr. Simranjeet Kaur Gill, Professor of Law from City University, Ludhiana. Today we will discuss the topic Lon L. Fuller's The Case of Speluncean's Explorer. So the case takes place in the equally fictitious Commonwealth of Newgate, and Fuller's article contains 5 judicial opinions that explore the fact from different legal perspectives. It is useful as an illustration of the scope and diversity of Anglo-American legal philosophy in the mid-20th century. Basic facts of the case are as under. A group of cave explorer speluners are trapped by the landslide approaching starvation. They make radio contact with the rescue team. Engineers on the rescue team estimate that the rescue will take further 10 days. After describing their situation to the physician, they told it is unlikely that they will survive another 10 days without food. The explorers asked the physicians whether they would survive if they killed and ate one of their number. The physician advised reluctantly that they would. When asked if they ought to hold a lottery to determine whom to kill and eat, no one on the rescue team is willing to advise. The radio is turned off and later a lottery is held. The loser is killed and eaten. When they are rescued, they are prosecuted for murder, for which in the Commonwealth of Newgate, a guilty verdict carries a mandatory sentence of capital punishment. The opinion of the judges are as under. The defendants were initially convicted and sentenced to be hanged by the Court of Journal Instances of the country of the Storefield, but have brought a petition of the error before the court. Trupani provides a more complete overview of the fact than is above. Each judge gives a separate opinion. Now we will be discussing the different opinion of different judicial officers. Judgment of Trupani, Chief Justice. So the statement of facts were briefly discussed in the case. The 4 defendants and the accused were part of the Speluncean Society cave exploration organization and became trapped in the cavern as a result of a landslide. The remote location made rescue difficult, time-consuming and expensive. 10 workmen were killed in the rescue. After 32 days, they were rescued. Early on it was recognized that death by starvation was a possibility. On the 20th day, it was realized that the explorer had a two-way radio of sorts and oral communication was established. The engineers informed the explorers that at least 10 more days would be needed to rescue them. Upon further inquiries, a team of medical experts informed that explorers that considering the condition and rations inside the cave, the chances of the survival for further 10 days were remote. The explorer asked whether they would survive if they resort to cannibalizing one of the number. It was reluctantly confirmed they could. Furthermore, asked if casting lots as to whom should be eaten was advisable. No physician, judge, government official, minister or priest would provide an answer. No further messages were received from within the cave. When the explorers were released, it was learned that on the 23rd day after entering the cave, Wedmore had been killed and eaten. The defendant's testimony accepted by the jury was as follows. Wedmore proposed that they derive the necessary sustenance from the killing and eating one of their number. Wedmore also proposed casting lots. Using a pair of dice, he happened to have with him. Initially, the defendants were reluctant to adopt this desperate measure, but agreed when hearing the radio conversations. The explorer devised and agreed upon a method of using the dice to cast the lots. Before the dice were cast, Wedmore withdrew from the arrangement, claiming he would wait another week. The others charged him with a breach of faith and proceeded to cast the dice. Before throwing the dice on his behalf, the defendant asked Wedmore to declare any objections to the fairness of the throw. He did not object, and the throw went against him. Wedmore was put to death and eaten. The defendants were treated for malnutrition and shock, then indicated for murder. At trial, the foreman of the jury, a lawyer by profession, asked the court whether the jury could find a special verdict that left it to the court to say whether, on the facts as found, the defendants were guilty. Both prosecution and defendant accepted this. On the fact as found by the jury, the trial judge ruled the defendant were guilty of murder and sentenced them to be hanged. The mandatory sentence post-trial, the jury joined in a communication to the chief executive of the New Girth, requesting the sentence be commuted to imprisonment of 6 months. The trial judge did similar. The chief executive waits for the Supreme Court's disposition of the petition of error before making a decision regarding clemency. Judgment of Trupani, Chief Justice, holds the course taken in the first instance to be fair and wise, and the only course open to be taken. The Chief Justice acknowledges that no exception to the statutory provisions applies, regardless of how sympathetic people may be. The Chief Justice preferred to rely on possible executive clemency, described as mitigating the rigors of the law, and proposes that the Supreme Court joins in the communication to the Chief Executive, expecting clemency to be granted. Justice can be done in this way without disregarding either the letter or the spirit of the law. Thus, Trupani, Chief Justice, uphold the conviction. Judgment of Foster. J. Foster criticizes Trupani's Chief Justice's attempt to escape the embarrassments of this tragic case. His Honour believes that very law of New Girth is on trial, and if the defendants are found to have committed a crime, the law of New Girth is convicted in the tribunal of the common sense. The first ground for this opinion is that positive law's foundation is the possibility of human social coexistence, where this coexistence becomes impossible. The condition underlying the law cease to exist. Foster J. holds that the explorer were the outside the jurisdiction of commonwealth. If we look to the purpose of the law and government and to the premises underlying our positive law, these men, when they made their fateful decision, were as remote from a legal order as if they had been thousands miles beyond our boundaries. The explorer were not in state of civil society, but in state of nature, and consequently the law of the Commonwealth of New Girth do not apply. The principles of law to be applied are those that were appropriate to their condition, and under those principles they were guiltless of any crime in common law jurisprudence. Such approaches have been rejected, considered as the leading example of the case R versus Dudley, where necessity was rejected as a defense to murder. In that case, two shipwrecked men killed and ate a cabin boy who was in the coma. Foster J. argues that it has from the antiquity been recognized that most basic principle of law or government is to be found in the notion of contract, and consider that agreement to cast lots was a new charter of the government appropriate to the situation. Dismissing skeptics, Foster J. asserts it's clear that Newgart's government is founded on some sort of voluntary charter of a government to which the current government can trace itself. The authority to punish is derived from the original compact and no higher source. What higher source should we expect? The starving, unfortunate to the find for the order they adopted for themselves. Foster J. illustrates this with the fictitious example Commonwealth versus Tamor, where the law was not applied because the defendant was unable to avoid breaking the letter of the law. A second example, Feller versus Negas, involved a clear typographical error and the court did not take literal interpretation. Foster J. argues there is nothing in the wording of the statutes that suggests an exception of a self-defense. The truth is that the exception is favor of self-defense cannot be reconciled with the world of the statutes, but only with its purpose. Foster J. then goes on to discuss the reasoning behind the self-defense exceptions, arguing that law cannot deter killing in self-defense. Where a person's life is threatened, in such cases, the killer will repel his aggressor. Whatever the law may say, Foster J. applies this reasoning to the explorers. The law does not create a significant deterrent to the persons faced with starvation. Judgment of Tatting. Justice Tatting begins by stating that in his duties as a judge, he is normally able to separate the emotional from the intellectual reactions and decide the cases based solely on the latter. His Honor concedes that it's not possible in this case for him to do that, finding himself torn between sympathy and adherence and unable to dismiss these considerations. His Honor finds Foster J. opinions short thought with contradictions. Tatting J. is critical of the state of nature. Argument finding that there is no clear basis for the assertions that the explorers somehow escape the jurisdiction. His Honor cannot pinpoint when the supposed transition of jurisdiction occurred. Tatting J. also points out that court of Newgate are empowered to administer the law of that commonwealth and questions from where the authority to decide the cases under the law of nature would possibly derive. His Honor then examines the content of the code of nature proposed by Foster J. and describe it as odious. Under the agreement, for example, Weathermore would not have been able to exercise his right to self-defense in the cavern, as it would be contrary to the bargain. Tatting J. finds the notion that criminal law relating to murder cannot operate as a deterrent where a person is faced with the alternative of life or death to be convincing. Citing the fictitious case Commonwealth versus Perry, Tatting J. agrees that interpretation of self-defenses provided by Foster J. is supported, though the case seems generally to have been overlooked in the text and subsequent decisions. Nevertheless, His Honour states that deterrence is not the only purpose, orderly retribution, citing Commonwealth versus Cape, and rehabilitation of the wrongdoer, citing Commonwealth versus Makeover, are two examples. What do we do when it has many purposes or when its purposes are disputed? But conversely, the taught doctrine in the law school is that the man who acts to repel an aggressive threat to his own life does not act willfully, but in response to an impulse deeply ingrained in human nature. His Honour holds that in the case of explorers, they acted not only willfully but with great deliberation. Tettinger then describes the two paths available, either to follow the virtually unknown precedent of the Supreme Court in Commonwealth versus Perry, that the crime of the murder does not sufficiently deter those whose lives are threatened, or to follow the conventional doctrine of self-defense taught in law schools, that it is not a willful act, but which, so far as I know, has never been adopted in any judicial decision. Tettinger appreciates the significance of the precedent relating to the juridical corrections of the legislature error, but inquires as to whether the court should be expected to disregard or overturn the precedent. In Commonwealth versus Wagen, where a defendant was convicted for stealing a loaf of bread despite the probability that he would starve, while the circumstances do diminish the element of deterrence, it does not remove the culpability of the explorers entirely. Tettinger is unwilling to create a new exception to the murder on the basis that scope would need to be adequately defined for the application in future cases. Judgment of Keene. Justice Keene immediately set aside two questions that, in his opinion, are not the matters for the court, that of executive clemency and that of morality. Executive clemency is a matter of the chief executive, and the judiciary should not be seen to breach this separation of powers. Keene would pardon entirely the defendants on the ground that they had already suffered enough, but this is a remark made as a private citizen, not as a judge. Nor does Keene concerns himself with the question of right and wrong. Judges are not to apply their conception of morality, but to apply the law of the land. Lord Mustier's dissenting opinion was that morality ought to be set aside, and informed consent to the private act of violence will be sufficient to escape conviction. The sole question before us for decision is whether these defendants did willfully take the life of the Roger Whitmore. I should suppose that any candid observer would concede, and once that these defendants did, Keene states that the difficulties in deciding the case arise from the failure to separate the legal and moral aspects of the case. His Honour criticizes his fellow judges for shirking their responsibility to abide by the word of the law. His Honour is determined to put personal views aside. Keene is averse to Foster J's a purposive approach to statutory interpretations that would allow the court to justify a result it continues proper. Keene then provides a recount of the historical background of the judiciary's position, as judges did in fact legislate very freely at a time when the accepted principles of political science did not designate with any certainty the rank and the function of the various arms of the states. We now have a clear-cut principle, which is the supremacy of the legislative branch of a government. Keenjay turns his criticism towards Foster Jay's personally, stating that his colleague does not generally respect the restricted role of the judiciary. His Honour uses Foster Jay as a prominent example of judicial reform of the legislative enactments. The process of judicial reform is described as being in 3 steps. The first one is assigning a single purpose for statutes, despite no single purpose existing in any statutes. Another one, discovering that the legislator overlooked or omitted something from the statute. The third is filling in the blank that is created as a consequences. His Honours state that Foster Jay's interpretation is flawed because Foster Jay is attempting to inculcate some purposes not revealed in the statute, but goes further than Tatting Jay. His Honour does not believe the purpose needs to be explained by further than being a deeply felt human conviction that murder is wrong and that something should be done to the man who commits it. Keenjay believes that inquiry should not be directed towards the purpose of the statutes, but towards its scope, and likewise the exceptions. The action of the defendant clearly fall within the scope of the statutory provision. A hard decision is never a popular decision. Keenjay firmly states that judicial dispensation does more harm in the long run than hard decisions, and concludes that the conviction should be affirmed. Judgment of Handy. He states that I never cease to wonder at my colleagues' ability to throw an obscuring curtain of legalism about every issue presented to them for decision. Handy J holds the case to be one of the application of the practical wisdom, not abstract theory, and one of the easiest to decide. Government is a human affair in which people are ruled well when their rulers understand the feelings and conceptions of the masses. Of all the branches of the government, the judiciary is the most likely to lose its contact with the common man. When a set of facts has been subject to the judicial treatment for sufficient times, all the life and the juice have gone out of it, and we have left a handful of dust. Handy J describes the distinction argued by the lawyers between when rules and principles ought or ought not to apply is a necessary evil, a consequences of formal regulations. His Honour prefers wide discretion and dispensations for the judiciary, save for a few fundamental areas, that is, conduct of the elections and appointment of the officials. We should take as a model, I think, the good administrator who accommodates procedures and principles to the case at a hand, selecting from among the available forms those most suited to reach the proper result. The most obvious advantage of this method of the government is that it permits us to go about our daily tasks with the efficiency and the common sense. Handy J discussions at the length of the publicity surrounding the trial as well as indications of public opinion. 90% of the respondents to a major poll believed the explorers should be pardoned or given a token punishment. Handy J states that to preserve the accord between the judiciary and the public opinion, a declaration of innocence ought to be made. Certainly, no layman would think that in letting these men off we had stretched the statute any more than our ancestors did when they created the excuse of self-defense. His Honour then acknowledges that his fellow judges will no doubt be horrified by the suggestions of taking into account the emotional and capricious public opinion. They will tell you that the law surrounds the trial of a case like this with elaborate safeguards designed to ensure that truth will be known and that every rational consideration bearing on the issues of the case has been taken into account. Handy J lists 4 means of escaping punishment. The first one is a determination by a judge that the accused has committed no crime, a decision by the prosecutor not to ask for an indictment, an acquittal by a jury, or a pardon or a commutation by the executive. And the states within this framework there should be no pretense that factual errors or emotional personal factors are excluded. His Honour provides jury nullification as an example and states that jury would likely have acquitted regardless of any instructions given to them, and that this way was the only prevented by the fact that the foreman was a lawyer whose learning enabled him to devise a form of words that would allow the jury to dodge its usual responsibilities. His Honour points out that Truepenny CJ and Tatting-J wants common sense to decide the case. Tatting-J want it prior to the trial at the prosecutor's stage, and the Truepenny CJ wants it after the case through clemency. That the chief executive is determined not to commute the sentence if the verdict is upheld. His Honour describes one of the first cases he presided over when he joined the bench, stating that on a common sense approach applicable then was applicable now. He concludes that taking a common sense approach that considers his above discussions, the defendants are innocent and the conviction should be set aside. In a concluding remarks, Tatting-J was asked by the Chief Justice whether he wanted to re-examine his position, but His Honour declined and affirmed he would not participate in the case. The Supreme Court, divided evenly, affirmed the conviction. Fuller provides no further detail as to the outcome. Thank you, viewers, for watching this program.